Now, Ernie Larking needs no introduction. He's so well known in tax that I'm just going to practically hand over to him. We read his name in the tax court cases. He's going to talk to us about dispute resolution and the Tax Administration Act. Ernie, thanks for doing it.
With the disputes with SARS ongoing and increasing in frequency as a result of the tax revenue collection underruns, and our poor economy continues to stagnate and even shrink, it's a reality that all taxpayers will face a more aggressive SARS, and as a result there is going to be inevitably more tax dispute. With SARS's extended powers in information gathering, I think if you look at the additional powers that they have on information gathering, what they can demand from taxpayers in terms of opinions that you've received, written opinions you've received from your advisors, you must understand that it's no longer business as usual, and that when receiving written tax advice from your consultants, the importance of subjecting it to the protection of legal privilege will become increasingly self-evident. And what we are seeing is the new battleground is in the international arena of base erosion, profit shifting, and transfer pricing. And the acronym BEPS covers a lot of sins: tax treaty abuse, or perhaps substance over form. Covers a lot of areas. So if we look at an assessment is a determination of a tax liability or a refund by way of self-assessment by the taxpayer, or an assessment by SARS, and any taxpayer who is aggrieved by an assessment may object to that assessment. We'll come to the issues of reasons and whether you should apply for reasons under Rule 6 or Rule 52 or under PAJA. I think there's been previous speakers on this particular issue, and of course I respect their views. My views may be different. I missed the earlier discussions, but let's have the conversation. So essentially there are two kinds of disputes with SARS. There's disagreements on interpretation of law, and in these disputes the normal dispute resolution steps are followed: objection and appeal, alternative dispute resolution, appeal to the tax board, appeal to the tax court, and if necessary further appeals to the higher courts. And that you'll see in Chapter 9 of the Tax Administration Act. The other dispute would be disagreements on administration of law, and complaints there can be reported at the SARS contact center or at branch level, or it may be escalated to the SARS Service Monitoring Office, further to the SARS Service Escalation Office at head office, and even to the tax ombud. But of course you can go directly to the tax ombud if there are compelling circumstances to contact the tax ombud directly. So if we look at Chapter 9 of the Tax Administration Act, it provides the legal framework, and Chapter 9 in itself contains sections 101 to 150 dealing with the dispute process, and there are 6 parts in Chapter 9. Part A is the general section, Part B, objection and appeal, Part C is tax board, Part D is the tax court, Part E is the appeal against a tax court decision, and Part F is the settlement of dispute. Chapter 9 of the Tax Administration Act does not apply to customs and excise duties. Customs have their own procedures and dispute resolution. Chapter 9 and the rules and procedures issued under Section 103 of Chapter 9 must be read together. So in addition to the statute and the sections in Chapter 9, you must read it together with the rules promulgated under Section 103. And the rules prescribe the procedures to be followed when lodging an objection. When lodging an objection and appeal against an assessment or a decision from SARS, it sets out the procedures.